All right, it's time to look into what's trending in employment law. Lawyer, you're on the clock.
Phil, we got just a handful of topics today that I want to get through real quickly before we get to our other segments. And the first one, our Eighth Circuit Court of Appeals here in Missouri, the federal Eighth Circuit Court of Appeals that's based here in Missouri, is set to weigh a pretty significant issue. And it's going to be weighed before the full Eighth Circuit Court of Appeals. And they're going to decide whether an employer defense is applicable in Americans with Disabilities Act lawsuits. The Court of Appeals for the Eighth Circuit's 11 active judges are set to hear oral argument today in a case involving a Hardee's restaurant manager who said she was fired because of her diabetes. The restaurant originally won the case on summary judgment at the district court level, and then on appeal, it was overturned in a 2-1 decision, which meant that the Hardee's restaurant was going to have to face the claim of an Americans Disabilities Act trial, and a jury would decide whether Hardee's violated the law or not. In this particular case, there's a doctrine out there called the honest belief doctrine. And under that doctrine, that shields a company from workplace bias claims if the company can offer a legitimate reason for a firing or other adverse job action that was based on incorrect information that they reasonably believed to be true at the time. Okay.
All right. So let's break that down. Meaning, with the information I have, I believe the data that I have is what I have, and I'm making a decision on that data. Whether that data is completely accurate or not, that's the honest belief doctrine, meaning that's right. I made the decision based upon those facts.
Yep. I honestly believe these to be the facts, and that's what I made the decision on. The company should have provided for some additional relief or consideration of the absence that led to the termination, or the reasons for the absence that led to the termination.
Yeah. Now, I know many of our members will have, and I've had them when I was practicing HR. We had no call, no show policies where, if you were a 2-day or 3-day consistent no call, no show, or after your second no call, no show, you were terminated. I wonder, is that putting that practice as it sits by itself in isolation at risk, meaning you can't or shouldn't make a decision on termination based on one instance or 2 instances of no call, no show alone. You should investigate.
Yeah, I think that you can make a decision, but I think that decision is subject to being revisited in certain circumstances if the employer gains more information down the road. And an example of that might be, say you have an employee who gets into a terrible car accident on a Sunday night, and then doesn't report to work Monday, Tuesday, Wednesday. Nobody's heard from this employee, and that's because the employee is literally comatose in a hospital. The employee can't call in. So the honest belief doctrine would say, well, we honestly believe the employee abandoned the job, and so we made the decision. If the employee later comes back from the coma, wants to return to work, as soon as they come out of the coma, they have a family member reach out to the employer, let the employer know what happened. I think a prudent employer would want to possibly reconsider that decision.
Yeah, and it sounds like in this case, it's the employer is aware that the person was struggling with a serious illness of diabetes and maybe didn't take that into account in its decision. And I think the tough part for that, particularly for business owners and HR professionals, is, and I'm not saying this is the case every time, but many times, we get frustrated with people who are gaming the system, trying to, determine when is someone gaming the system, or when are they using the system to their advantage and the employer's disadvantage, and what is the employer to do, right?
Right.
And that, I'm not saying that's the case here, but I know that's the struggle that we deal with. And I think that's when it's right for an employer to get into conversation, with our advisors or your legal team, and make sure that, we're covering all angles when we make that decision.
Yep.
Yeah.
Tread carefully.
Well said. What else you got there, Mr. Lawyer on the clock?
All right. So, Phil, you mentioned in the opening that it's, or maybe Nick mentioned in the opening that it's election season. I thought it'd be a good time to very quickly
We got an
review.
election coming up.
Yeah, I'm hearing some buzz about that out there, just a little.
Who are the candidates anyway?
Yeah, who knows? Who knows? So I thought that it'd be a good time to cover the election laws. I know that we're primarily focused on our audience here in Missouri, in Illinois, and then audience members in Indiana and Florida. So just as a refresher for all of our folks listening, you could see there's a map that I have pulled off of Ogletree Deacon's client portal that shows the states that have voting laws, voting leave laws, and states that don't. You can see for our Florida and Indiana folks that the state does not have a voting leave law, which means that I would strongly encourage employers in those states to allow employees to take a little bit of time off work to vote, maybe come in late, leave a little bit early to vote if they don't have time to vote outside of working hours. So in those states, that's how I would handle it. Missouri and Illinois, however, do have voting leave laws, and the Missouri law says employers must allow eligible voters to take up to 3 hours of paid leave to vote unless the employee has 3 consecutive non-working hours before or after their regularly scheduled working hours to do so. The employees must request voting leave prior to election day, and the employer may specify which hours can be taken. Okay, so I want to make that very clear in Missouri. Illinois, employers must allow employees to take 2 hours of paid leave to vote during working hours if the employee's working hours begin less than 2 hours after the opening of the polls and end less than 2 hours before the closing of the polls. Employers may specify the time period for such leave. The employees must request the leave prior to the date of the election.
Yeah, I think a couple of things there is in both states, while the time frame is different, both of them require advance request and notice.
That is correct.
And let's just practice this out loud for a minute. If the polls are open at 6 in the morning and my shift starts at 8 and I work until 3 or 4 in the afternoon, but the polls are open until 8 or 9 o'clock at night, there would be no reason for me to accommodate because I have at least 4 hours in that scenario to get to the polls and vote.
That's right.
Yeah.
That's correct.
Okay.
So one other caveat, Phil, for Illinois, though, I want to mention that Illinois, we've talked about it on the program recently. This year, it went into effect. Illinois has what we like to refer to as the Paid Leave for All Workers Act, or Paid Leave for Any Reason Act, as I like to call it. Illinois requires covered employers to provide employees with paid leave that can be used for any reason. And an election would be any reason. So keep that in mind in Illinois.
Now, and put that aside, me using my earned time off in the state of Illinois, this doesn't mean that the employer has to provide paid leave if the person is assigned to work voting polls or they volunteered to campaign, on the steps of the voting building before that. This is to vote, not to support a candidate or a position.
Definitely not to support a candidate. Missouri does have a leave law associated with being a poll worker. And whether Illinois has one of those or not, I'm not sure. I don't believe they do.
Okay. Yeah. Good stuff.
Right.
Yep.
Now,
That's going to be important for us to remember for, I guess, 2 weeks now.
Yeah, exactly.
Just
A
under
little
2
less
weeks.
than. Yep. And now it's interesting with the applicability of these laws with so much early voting taking place in most states these days. You would think that an employee would be able to find time to vote, early vote, and not invoke these laws. But make sure you take that into consideration as well. And I mentioned, Phil, the Illinois Paid Leave for All Workers Act, not to be outdone. Not to be outdone at all. On a lighter note here, and by the way, it's a lighter note, but this is definitely something I can get behind here. The New York City Council has proposed
Wait a
giving.
minute. I got to stop you.
All
You're
right.
going to get behind something that's going on in New York City.
I can get behind this one, Phil. I kind of like this idea.
Okay, I'm tuned in.
All right. So this New York City Council proposal would give workers time off for pet care. I mean, that seems completely reasonable to me.
I know you could get behind that. I wonder, does pet care mean my dogs have escaped? They've run a mile or two down the road through the neighborhood and are having a chicken dinner in someone's backyard.
It might mean that this law as proposed would basically mean that it would cover service animals and, quote, any animal kept primarily for companionship in compliance with all applicable laws, and would allow people to take time off to care for pets or service animals under that bill. Not sure if caring for those animals would cover my dogs escaping again and going and raiding some of these chickens in their backyard, but I would like to think it would.
Yeah, I have a lot of opinions on that one, but I'm going to keep them to myself because I'm not sure most of our listeners would agree with them. However, I do want to share, we were stuck in the hurricane not that long ago, came through Central Florida, and we were in a hotel there. And many of the people that came to check into the hotel came to get away from, low-lying lands or to be extra safe, in a big, strong hotel building, and they brought their pets. Of course, their pets could not be left unattended. Now, everyone brought dogs, to the best of my knowledge. I didn't see any cat lovers there. But it was interesting, as we were all sitting in the lobby and the power is out and there wasn't anything to do, the number of people that would allow their pets to get up on the hotel furniture, like the couch, the chairs, the sofas in the hotel lobby. And I don't know, I just found that to be a little bit disrespectful. But that's me, and some people don't buy into the fact that I'm a respectful pet owner myself in that way. But I just found that to be, I could only see my dad going, "Get your dog off of that couch." Yeah.
That went too far for you.
Yeah, that one went too far.
Yeah, I get it.
Yeah.
Thank you once again for tuning in to This Week at Work. If you enjoy the show, please share it with your colleagues. Forward our invites. Share the link, aimea.org/thisweekatwork, or follow or subscribe wherever you get your news and entertainment, like LinkedIn, YouTube, Spotify, Apple Podcasts. We're everywhere you are. And you can be part of the show. Send your questions and comments anytime to info@thisweek.work. We'll see you next week, 7:30 a.m. Central Time, when we discuss what's happening this week at work.